Got it. Got it.
Good afternoon, everyone. Thank you so much for joining us for the final round of the 2021 Upperclassmen Moot Court competition here at Nova Southeastern University. We are so happy to host you all. And good afternoon, everyone. Thank you so much for joining. There's that lovely echo. Love technology. But as I was saying, we have a great top two right here. We have Jessica Velarde and we have Gabriela Gonzalez. They have argued all weekend to make it to this point. They've gone head to head all morning and they have emerged victorious. So all of my congratulations to them. I would like to take a moment to congratulate all of the members that have made it onto Moot Court this weekend. We are so proud of you. It's really been a wonderful competition. I'd like to thank all of the judges that have volunteered their time over the course of the past 2 days. This competition would not be possible without volunteer attorneys, judges, and professors within the community who really just go the extra mile to give back to the next generation of attorneys. It means so much to us and our competitors, so thank you again. To our final panelists here today, thank you for your time. It's always a pleasure to have the opportunity to see you all. And I would also like to take a moment to thank our Executive Justice for Competitions, Lakshmi Apollinario. She has worked tirelessly this weekend for the past 2 months to put this together and has truly been able to run such a flawless competition thus far. So Lakshmi, wonderful job. Thank you so much. To our Executive Justice of Academics, Jonathan, thank you for all your work behind the scenes. You may or may not know this, but Jonathan is in charge of scoring this whole competition. So while we have worked tirelessly on the front lines, Jonathan has worked arguably even more tirelessly behind the scenes in order to make sure that every round is scored accurately and everyone's advancing, and he does so much for us. So thank you, Jonathan, for all your hard work. And to Gloria, thank you for all that you've contributed this weekend, our Executive Justice for Teams. I'm sure Gloria's been keeping a very close eye on our competitors and she knows who she's about to call for our national teams. So without further ado, I'm going to go ahead and turn it over to Lakshmi for some brief introductions, and then we will go ahead and get the round started.
Thank you so much, Kelly, our Honorable Chief Justice. At this time, I would like to introduce Judge Raj Singhal. He is a United States District Court Judge for the Southern District of Florida. He earned his JD from the prestigious Wake Forest University School of Law, and soon after he entered the field of criminal law as a prosecutor and then was a criminal defense lawyer for 18 years. In 2011, Justice Singhal was appointed as a judge of the 17th Judicial Circuit of Florida by Governor Rick Scott and assumed his position until 2019, when he was appointed to the United States District Court for the Southern District of Florida. Judge Singhal is the first Asian, Pacific American, and Indian American to serve as an Article III federal judge in the 11th Circuit. Mr. Michael Stevens is an NSU Shepherd Broad College of Law alumni who earned his JD in 2008 and began working at Derriere, Stevens, Black & Kozak. In 2013, Mr. Stevens was made partner until the summer of this year, when he was then appointed as the firm's managing partner. He also assumes the chair of the firm's real estate and subrogation divisions and practices in a wide array of fields such as insurance subrogation, landlord-tenant law, products liability, corporate and business transactions, and more. Mr. Stevens was first appointed to the Florida Bar in 2008, but later earned a certification to practice in Massachusetts, Vermont, Connecticut, and the District of Columbia. Ms. Lena Abdin is a 2021 summa cum laude graduate from NSU. Before she attended law school, she received a Bachelor of Science with a major in political science from FIU. She also earned her master's degree from the Johns Hopkins School of Advanced International Studies. During her time at the Shepherd Broad College of Law, she was published in the Nova Law Journal, Volume 44, where her article was titled Banning Faux Sanctuary Jurisdictions. And then she was also published in the WHO's Eastern Mediterranean Health Law Journal, where the article was titled Antenatal Care for Syrian Refugees in Beirut, Lebanon, in 2018. Ms. Abdon served as our former Chief Justice prior to Ms. Kelly O'Neill taking the reins. And following law school, she joined Cole, Scott, and Cassane as an associate. She currently practices in catastrophic and personal injury protection, PIP, and in the Special Investigations Unit for Insurance Fraud Defense. Mr. Sean Thompson received his JD from the Shepherd Broad College of Law in 2004 while working for the Public Defender's Office in the 17th Judicial Circuit of Broward County as a certified legal intern. However, following law school, he was immediately employed in the Medical Malpractice Division of Krupnik in Campbell. In 2019, Mr. Thompson founded a multi-partner firm titled Lieberman, Cabrera, Thompson, and Reitman, where he practices trial work in the fields of medical malpractice, wrongful death, and products liability. Mr. Thompson is frequently involved with NSU and was recently named in the NSU Shepherd Broad College of Law Board of Governors. And last but not least, Miss Bethany Pander, valedictorian, summa cum laude graduate, and former Chief Justice of NSU's very own Moot Court Society. She received her JD in 2018 and began working as an appellate associate at Greenberg Traurig, an international multi-practice law firm founded in Miami, Florida. She litigates and represents clients in multiple fields, including business tort claims, trade secret litigation, and employment disputes. During her time at NSU, she also served on the executive board for Nova Law Review, where she was published in her for her 2017 article titled Changes Required, ABA's Crackdown on Lenient Law School Admission Policies. With regard to our final competitors, we have Jessica Velarde and Gabriela Gonzalez. We are so very proud of you. And now, with that being said, I would like to officially pass the torch over to the former winner of the 1L Fine Writer competition, Ms. Jordan Stein, to please call the case.
Good afternoon, everyone. Please stay muted. I have a few housekeeping matters to address. First, please make sure that you all are in gallery view so that you can see everyone on the screen at the same time. If you need help with that, please send an applause reaction. Second, please make sure you have hidden non-video participants. If you need help with this, please send an applause reaction. Okay, seeing that there's none, we'll move on. Who is the movant in this case?
I am.
Will you be reserving time for rebuttal?
Yes, just 1 minute.
Okay. Competitors, please keep yourselves on mute until a judge indicates it's your turn to argue. I will be keeping the time using the chat function to be notifying you how much time you have left in your argument. You will be notified at the 5-minute mark, 3-minute mark, and 1-minute mark. I recommend that you keep the chat function open so you do not miss any notifications. Judges, if you're ready to start, I will begin the opening remarks. Once I finish opening remarks, I will turn off my video and turn it over to the judges to call the case. The timer will begin when the competitor begins speaking. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Counsel for the petitioner.
Chief Justice, Your Honors, may it please the court. My name is Gabriela Gonzalez, and I'm here today representing the petitioner, Keystone Quick Care, in this case. Petitioner respectfully asked this court to reverse and remand the lower court's decision that found respondent standing for 2 reasons. First, respondent did not sustain a sufficient harm to satisfy standing. And second, as a matter of public policy, this court should not hold a routine communicative tool as a leg for frivolous claims to stand on. To my first point, the lower court erred in allowing respondent standing, as stated in Summers versus Earth Island Institute, Without a factual showing of a perceptible harm done by the challenged action, standing is not satisfied. In this case, Your Honor, respondent is alleging the receipt of a discount code for a flu vaccination was a perceptible harm. Thus, respondent would like the court to view this text message as an invasion of her privacy. That is not the case. Under Article 3, in order to establish standing, an injury must be concrete, particularized, actual, and/or imminent, and can be redressed by a favorable ruling. Under the Act, an unsolicited advertisement is the commercial availability or quality of a good or service which is transmitted to any person without that person's prior express invitation or permission. However, there are...
In this case, didn't the respondent specifically tell your client that she did not want to be contacted?
She wrote down that she did only wanted to be called and not texted, but petitioner did not specify what form of communication her test results would be delivered to her. The exceptions under the statute.
I apologize, counsel. There's a slight delay. Should that be determinative? Does she need to advise how she received this information?
She does not need to. Your Honor, your internet was cutting off, but if I understand your question correctly, is whether she had to tell the petitioner what form of communication she wanted the test results to be delivered. Is that correct? Okay, so
that is correct.
Under the statute, it's not specific as to whether the respondent was entitled to request certain information. And on her patient form, it didn't specify what form of communication she could have selected. Under the statute.
So does that help or?
So
I'm sorry, continue.
Okay. However, there are exceptions to this statute. The intent of Congress were to ban these automated or pre-recorded telephone calls to the home was because it was seen as a nuisance and an invasion of their privacy. But Congress specifically articulated such calls are necessary in an emergency affecting the health and safety of the consumer.
So, Counselor, is it your position that the respondent doesn't have standing because she consented? Is it because of the emergency exception, or is it she doesn't meet one of the elements for standing?
She does not meet one of the elements for standing because the harm was not, there was no harm to be done. And this goes back.
Counselor, isn't the whole point of the Telephone Consumer Protection Act that the harm is the actual receipt of the advertisement, which you don't dispute here? So isn't this the exact kind of harm that the statute was designed to protect against?
Yes, it is the exact harm that the statute was designed to protect. However, the exceptions fall into that as well, whether it be the emergency or an additional exception would be the established business relationship between sender and recipient, as is present here in this case, because respondent was required by her employer to seek out medical services through the petitioner in order for her to go back to work.
Excuse me, going off Justice Pander's question, several courts have found that simply receiving a communication violated the TCPA, and that constituted an injury in and of itself. Why should we depart from this reasoning today?
Yes, Your Honor. They did specify that the text message was the harm. However, under this case, the respondent provided the only contact information that was available to her. And again, the petitioner did not specify what form of communication was going to be used to deliver the results. And the respondent is alleging the text message in its entirety is the harm that's done. However, the text message included personal health information that she was required to receive and show to the employer. It is the duty of the petitioner as a public health institution to provide their patients with health information that would mitigate or reduce the harmful effects of any diseases during a global pandemic.
Counselor, just briefly, since the TCPA permits seeking either a monetary damage as a form of relief or actual injunctive relief, doesn't that suggest that the legislation did not intend for there to be a required injury in fact, for there to be standing for this type of cause of action?
Your Honor, as Chief Justice Roberts articulated in Campbell Ewald Company versus Gomez, there is no principle more intrinsic to the judiciary's proper role in a democratic government than the barrier imposed on federal courts' jurisdiction to actual cases and controversies. The receipt of a text message is not a controversy. It is not a concrete injury in fact.
So on that point, then, what scenario could you provide where a text message would ever fall under this act to give someone standing to bring either a cause of action for even just injunctive relief?
In Van Patten versus Vertical Fitness Group, the court determined in order for a respondent to give consent to receiving such a text message, the consent must be considered to relate to the type of transaction that evoked it. Here, respondent consented to receiving her test results through some form of communication. And thus the text message, as we look at it in its entirety, did have information relating and pertaining to the purpose of her visit.
Counsel, is it your position then that if the text message only was the advertisement, that it didn't include the test results, that you would agree with the respondent's argument?
It would have to vary case by case, Your Honor. In this case, however, the text message did include personal health information that she needed. Whether that text message could have been separated from the discount code is something that should be discussed whenever a fact and a case comes through the court system.
So I guess I'm just trying to follow up on Justice Stevens' question. Is it, let's assume that Ms. Walters was called 5 times a day, 10 days in a row. I'm sorry, not called, but texted. You'd agree that then text messages would violate the TCPA because that would be 40 or 50 text messages, right?
However, she did seek the petitioner's medical services, thus constituting an established business relationship, which falls under the exception in the statute. So my second reason, as a matter of public policy, if this court were to acknowledge the receipt of a text message, a customary communicative tool as a concrete injury in fact, it would furnish an inequitable distribution of justice and diminish the legitimacy of the federal judiciary. The petitioner was prioritizing communicating valuable health information that would benefit their patient and the public at large. The assumption that if respondents have no standing to sue, no one would have standing is not a reason to find standing. And to allow Congress to establish what constitutes as standing would erode the proper separation of powers between the two branches of government. To assess the requirement of standing is the business of the courts, not of the political branches. For the foregoing reasons, this court should reverse the lower court's decision and not allow respondent to claim injury by a receipt of a text message and to not be a party to the diminished authority and the abuse of the federal judiciary. Thank you.
Thank you, Ms. Gonzalez. And then for respondent, if you're ready, Ms. Velarde.
Chief Justice, Associate Justices, and may it please the court. My name is Jessica Velarde, and I represent the respondent in this case, Mrs. Rachel Walters. Your Honors, we are limited here today to a single issue, and that is whether, under the standing requirement of the United States Constitution, if a concrete injury in fact exists when an individual receives an unsolicited text message after explicitly demanding not to be texted. The United States Court of Appeals for the 11th Circuit answers that it does, and we respectfully ask this court to affirm that decision.
So are you talking about the Salcido case?
No, Your Honor. In this court, in the appellate court, the United States Court of Appeals for the 11th Circuit, they answered that it does equate to standing, and we respectfully ask this court to affirm that decision, and now we're on appeal. And this court should rule receiving an unwanted text message after explicitly demanding not to warrant standing in the federal courts, because the harm Mrs. Walter received when receiving the unsolicited text message is the exact harm.
I'm slightly concerned about the characterization of the text message as unsolicited, because don't you agree that the respondent came to came to the business and consented to receive the test results, and in fact needed the test results for her employment. So is the issue just that the delivery came through the wrong mechanism of the phone, or is it your position that she didn't consent to receive the information at all?
Yes, Your Honor. The harm here is receiving the text message. We recognize that KQC did have the permission to reach out. However, Mrs. Walters explicitly and unambiguously wrote in the form, as well as mentioned to the employee, that she did not want to be texted. Her exact words were that she do not text, call only. And she didn't stop. She went up to an employee of the petitioner and emphasized that desire.
So how do you respond to the petitioner's argument that the business relationship exemption would apply here?
Yes, Your Honor. So as to the established business relationship, it is not relevant once she said that she did not want to be texted. It's the receipt that was enough. And in Van Patten versus Vertical Fitness, which petitioner actually brought up, it's a Ninth Circuit 2017 decision. And that is where a gym had texted the plaintiff twice regarding gym membership after the plaintiff had visited the establishment before. And ultimately, the court held a concrete injury in fact did exist for Article 3 standing because the text message presented the precise harm and infringed on the same privacy interest that Congress sought to protect in enacting the TCPA. They reasoned that the text message, yes.
Counselor, what is this case and the Spokeo case that we ruled upon in 90, I believe it was Spokeo case, we ruled on that in 2011. What makes this so much different than that case? Back in it dealt with the fair care, the FCRA.
I'm sorry, Your Honor. I'm not sure. You came in and out with the Wi-Fi. I think that you asked, how did the Spokeo case differ?
Correct, from this current case.
Right, so the facts of Spokeo, if I may just look at my notes, the defendant operated a website that allowed for searching on other individuals' profiles. So the facts are slightly different, but really in that case, an injury is concrete if it actually exists. And the Supreme Court recognized that in some cases, the mere violation of a loan constitutes an injury in fact. And that is exactly what happened here. It was the mere receival of a text message. And Melito versus Experian, a Second Circuit 2019 decision, where plaintiffs each received an unsolicited spam text message from American Eagle Outfitters. The plaintiffs believed this to be a violation, and the court agreed, finding that the receipt of the unwanted advertisement is itself the harm. The disturbance the recipient received is enough. Mrs. Walters' situation was nothing different from that case we just mentioned. Petitioner did not adhere to Mrs. Walters' demands not to be texted that day, causing Mrs. Walters to suffer the harm of receiving unwanted advertisement.
But we're not talking, counsel, we're not talking about hours or multiple calls throughout the day. We're talking about one text message, are we not?
Yes, Your Honor, we are talking about one text message. However, it doesn't matter how many text messages that were received that day. The point is that KQC reached out in a way that she didn't want to be reached, and she explicitly and unequivocally said so. And let's just use life as an example. Let's say I go to a restaurant and I clearly and unambiguously state to my server, as well as the chef, that I do not want anything spicy. And after acknowledging this request, the chef, unfortunately, still made something extremely spicy. The restaurant would be in the wrong as I stated my preference and I'm the customer.
Unless you suffer no harm. And that's the issue. If you go to that restaurant, using your example, and you say no spicy food, they give you spicy food, but thankfully, nothing comes of it. Can you then bring a lawsuit for simply telling them, I did not want spicy food, yet you gave me spicy food?
Yes, Your Honor. Following the ruling in Melito versus Experian, it's finding the reasoning was that the receipt of the unwanted advertisement is itself the harm. So if we relay that in the example that I just gave, it's the chef cooking it and bringing it to my table. That is the receipt. I have received it, and now I am harmed. That is the harm. And under the statute, that is
what would be the damages there? So, and kind of playing off on Justice Stevens' question to petitioner, what does your client get with a victory here if we were to rule in your favor? It seems to me that Congress didn't write the statute in a way where they provided for damages in this particular situation. So really, what are you looking for?
Yes, Your Honor. Well, it would be dangerous and it would be harmful to allow an establishment, a medical provider nonetheless, to send messages to an individual that unambiguously and explicitly told them they did not want to be texted. The American legal system, it functions to seek justice and fairness, to punish those who break the law, which in this case is the TCPA. Once petitioner broke that law, Mrs. Walters gained the standing necessary to maintain an action in the court system. Now, we do understand that KQC was flooded with COVID-19 test results and appointments.
Right, and counsel, to that point, doesn't the TCPA expressly contemplate an exemption for the information that's transmitted in an emergency affecting the health and safety of consumers? So why wouldn't that exemption apply here?
Yes, Your Honor. Well, this was not an emergency. If we think of an emergency, we think of serious, unexpected, dangerous scenarios. Sending Mrs. Walters this text message with negative results in an advertisement was not a text message that needed to be sent right away in that instance.
But if we slightly changed the facts and she in fact had tested positive, would your position be different?
I believe so. Maybe if this were a positive result, which would mean she could be infecting others due to the times of COVID-19, then the situation would have been different. But that is not what is seen here.
Well,
instead,
let me just ask, following up on Justice Pander's question. I mean, the respondent here, your client, she's a teacher, right? I mean, she is basically right behind frontline workers right now. They're the ones that I think society is looking at the moment, trying to protect and really not just them, but the people that they are facing each day, the children in a place. So providing this information as quickly as possible with these new procedures that everybody's doing their best to try to work with as you get to the school year approaching. Why wouldn't you consider that something that would fit squarely within the emergency exception to this rule?
Absolutely, Your Honor. Well, the difference is that she stated that she did not want to be texted. So the difference between the minute or so that it would have taken to dial her number and to make it clear her results with that advertisement, then that would have been okay. But in an emergency situation, something that needed to be done right then in that second, that wasn't seen here. It was a negative test result, so she wouldn't have been infecting any others. And if it had been positive, then we might be able to say that there was more damage, but that is not the case at hand. That is not what happened here. And we have rights for a reason. We have rights to protect ourselves, for fairness, for dignity, for equality, and for respect. And we must uphold these rights, protect these rights, and recover when somebody violates these rights. Allowing petitioner, I'm sorry, I think that my time has expired. Might I have a brief moment to conclude, or if you were—
Absolutely. No, absolutely.
Your Honor, for the foregoing reasons, this court should affirm the United States 11th Circuit Court of Appeals because Mrs. Walters' privacy was invaded when she received the text message, and the text message was a nuisance. Thank you.
Thank you, Ms. Velarde. And then Ms. Gonzalez, you have a minute for rebuttal.
Yes, Your Honors. If respondent would like to claim a text message as a nuisance, a telephone call would just be more of a nuisance than a text message. She would have to stop what she was doing, answer her phone, and stop her day to get the results that could have been sent through a text message. And respondent brought up Spokio Incorporated versus Robbins. The court said that Article 3 standing requirements require a concrete injury, even in the context of a statutory violation. And as stated in Lujan versus Defenders of Wildlife, the court has consistently held that plaintiffs raising only a generally available grievance and claiming only a harm to his interest in proper application of the Constitution and the laws, and seeking relief that no more directly and tangibly benefits him or her than it does the public at large, does not state in Article 3 cases or controversies. A pleading must be something more than an ingenuous academic exercise, as respondent is doing here today. Thank you.
Thank you, Ms. Gonzalez. Thank you both for excellent argument. We're going to stand in recess so that we can talk about your argument, and we'll be back with you with our decision shortly.
Judges, if you may please just click join breakout room, and it will lead you right back into the judges lounge for deliberation. We're just waiting for the judges to exit. It's always funny because they always freeze.
I get it in, but
Justice Thompson, did you get the invite to join the room, or would you like us to send it again?
could you send it, please? I did not get it. Nothing.
1 second, I'm fixing it. How about now? Judges lounge.
No.
You
Is it
should.
in the chat or no?
It should be on the lower right-hand side. It should say join breakout room.
I'm on the iPad and I'm not seeing anything like that.
Left-hand side, you should see a little portion that says join breakout room on the top, where you should see three or four dots.
Got it. Yes.
No worries at all.
Sorry. Yes, got it. Thank you.
And then you may join them, and we'll be here waiting for you.
Wonderful job, ladies. We'll be back shortly.
Whew. And now for the moment of truth. I don't know about you guys, but I am sweating. I just want to go ahead and give you guys a wonderful. Let's keep it going. Let's keep it going. This has been an amazing, amazing journey. Now, before I show the screen as to all of our new Mooties that are going to be joining Moot Court, Jessica, how do you feel after making it so far? And if you may please tell us a little bit about your very inspirational story and your journey to Moot Court.
Yes, of course. Well, I didn't make Moot Court my 1L year, and then I tried out again my 2L year, and I also didn't make it. And I went through a portion where I was like, I can't do this, or I'm not going to be a good attorney. I can't even make a school team. And it took a lot to get me to retry. You can ask Lakshmi, you can ask Jonathan. They really had to push me to it. I waited until the very last night because I was like, if I don't make the team again, I don't know what I'm going to do. I'm going to feel really bad about myself if I can't make it again. So I ended up trying. I tried to actually quit Lakshmi, but she pushed me to do it. And I kept in my head, if I let my failures get to me every time, then I would never make it to the top. And I said, the only way that I can make it anywhere is to try again. And so I did. And here I am. So I'm really happy. Even just to make the team, I'm really happy. And a little bit, I think you asked a little bit about myself. I went to Florida State for undergrad. I am now a CLI, so I'm a certified legal intern for the state prosecutor's office, and I'm loving it. And around school, I'm an NTA, ILSA, and this is my time to plug Toastmasters, the public speaking organization. I'm president of that, so if anybody's watching and wants to join, it's open to the public too. And yeah, so thanks for having me.
Thank you so much. I really just want to say that Jessica's story is a prime example of being relentless and not allowing your failures, like you said, to define you. Our failures don't define us. And I hope that the people that tried out and that weren't able to make it onto Moot Court are able to learn from your story, because I too have I tried out for NTA, for example, and I didn't make it onto the first try, and that never stopped me. And the second time I made it around, I was in the top 14, but unlike my story, you actually made it to the top 2, and that is a very, very inspirational story. Let's give that a round of applause. Gabriella, if you may please tell us your story on how you got onto Moot Court, how you got here, and then tell us a little bit about yourself, please.
So I'm a 2L. My first year, I could not try out because of the GPA requirements. I was 0.02 away from making it. Yeah. And I went through winter semester and I worked my ass off. Summer semester, I worked my ass off. And I was like, I'm getting onto Moot Court, whether anyone likes it or not, but I'm going to. And I made it. And final round is literally like, could not imagine whatsoever. But yeah, 2L, I currently work at a property insurance firm. I'm really loving it. I'm their law clerk. I want to specialize in sports and entertainment. And I'm just excited to be in the society, to be amongst other really amazing lawyers, well, soon to be lawyers, advocates, and I'm excited. Yeah.
I love that. Okay, so very quickly, I'm actually going to share my screen so that everyone can see the brand new members of Moot Court. Can everybody see that? I just want to go ahead and say a round of applause to the Carolina Lafuente, Jessica Velarde, Carla Rosello, Jose de la Cabada, Maria Burbridge, Cheyenne Dallas, Gabriela Gonzalez, Carlene Vidal, Alejandro Gonzalez, which is here in the chat, Christina Moschella, Evan Carson, James Carpenter, James Zawalski, Pabla Nemikova, and Soika Sung. Soika is actually Suki. She's part of the Caribbean Law Student Association, the association where I'm a president. And if, Jonathan, you may please tell us a little bit about your experience scoring the entire competition and the brief writing and the brief scoring process, please.
Absolutely. So as Lakshmi mentioned, I had the pleasure of scoring the entire competition, grading all of the briefs along with an esteemed committee that was comprised of journal members, national competitors, and other highly qualified individuals, as well as drafting the bench brief and the problem for you all to argue here for this entire competition. So it was a very interesting experience seeing the problem come to light, seeing all of the different ways that the problem can be argued, all of the different ways that each side would choose to argue the problem. So it was an incredible experience. And as to scoring, all of the competitors in this competition did a phenomenal job, from brief scores to oral advocacy scores to the margin of victory or loss. It was an incredibly close call for the members of Moot Court and for the members that made the top 8. And it was a very difficult process to go through because each and every one of you all were just fantastic, and it made the deliberation process very difficult. But that's a great thing, because in that situation, you know, all of you guys are really, really deserving. And I would like to extend a very special congratulations to both Jessica and Gabriella. Both of you were fantastic. I had the opportunity to observe both of you in previous rounds, and to see your progression as the competition continued was just fantastic. And both of your stories are incredibly moving. And especially given the state of society now with everything that's going on, I think it's very important for everybody out there to hear these stories of triumph, and to hear these stories of struggle, and how ultimately you both were able to overcome. So congratulations to both of you. It's been a pleasure to run this competition along with Lakshmi and the rest of the executive board. I have no doubts that you both will be fantastic competitors nationally, internally, and fantastic additions to the legal community in due time.
Fantastic. Thank you so much, JB. We actually could not have this competition without you. You are a crucial member of this e-board. JB is always there. Sometimes he calls me at all times of the day and I always answer. So definitely want to give a round of applause. So in the interim, while we are waiting, let's see what is going on in the chat. We have Carla Rosello, one of our top 8 members. She said, congratulations, Jessica and Gabriela. We have Miss Jo Stanley. She was one of the judges in the top 8. She said, big props to the Moot Court board. She said, we have Catherine, Professor Arcabasio. She said, well done, Jessica and Gabriela. Alejandro Gonzalez, props to Gabriela for bringing Spokio. Alejandro Gonzalez said, great rebuttal. Well done. Ketia June, not sure who that is, impressive. And just so you guys know, we are going to be announcing the best brief of the competition as soon as the judges come back from deliberation. Joe Stanley said, good job volleying with the judges. Katia June, impressive. Talia Jarrett sending out a retweet for our female empowerment, the fact that we have an all-female top 2, and we almost had an all-female top 8, but Jose de la Cabada came in representing for the gentlemen. Professor Cross, she said, oh no, we're going down a spicy rabbit hole. That was great. I said, if I ever get spicy food, I'm suing. She said, interesting. Let me look at my notes. She liked the transparent vulnerability and the care, the attention to detail that you expressed, Jessica. What else do we have here? Always Yelene, I'm not sure who that is, but she said, you guys are fire. There was a lot of chaos in the chat when one of the judges threw you a hypo, but it seems that you caught it and killed that one. Okay. What else we have here? Alejandro Gonzalez came back. He is a brand new Moody. He said, they are both winners in my book. Super talented individuals indeed. Super sweet. Thank you, Alejandro. We have Sherry. She is a fellow member of the Craig S. Barnard Americans Inns of Court with me. It is a platinum organization, and we're so and always honored to have you, Sherry. Thank you so much for joining us and being a major part of this organization. She said, oh, good on Gabriela for clarifying the question. Excellent Zoom etiquette. Everybody liked that, Gabriela. That was a good way of bringing it back and catching it. It looks like we are finishing up deliberations soon. So the moment that we've all been waiting for is soon to arrive, people. Please stay tuned because the moment is almost here. Carla Rosello also is wishing you guys the best of luck. We have Riley O'Neill, that's the Chief Justice. I think that's, not sure, but I know it's Kelly's family. We have Lucio Rodriguez. She is a former top 2 as well. She said, good luck, Jessica and Gabriela. Herman S., great job to everyone. What a weekend. I know that was one of our judges. Sherry said, I'm loving the empowering stories and I concur with the props for the board. Lexi Samino, well done, Gabby and Jess. Very impressive round by both of you. Jose was good. Hernan S. said, congrats, Jessica. That was amazing. You had such a difficult panel. So we have currently approximately 42 people watching the live stream. So I'm really happy that you guys were not able to see that number because I'm sure it would have made you even more nervous. So in the interim, we are now going to be waiting for the moment of truth. I just received word that the judges are on the way back. Welcome back, welcome back. Welcome back, judges. How was that in there, Kelly? Give us a little bit of peek into the deliberations.
Well, I'm sure, as you can imagine, with a round like that, it was very tense deliberation. We discussed just about every aspect we could. We ultimately did come to a decision, but we want to provide the competitors with some feedback because you knocked it out of the park. You really impressed each and every one of us. So we would love the opportunity to go through and give you some insight. So with that, I'm going to turn it over to Chief Justice Singhal, and he's going to start us off.
You're muted, Judge Singhal.
And I just want to be clear, though, you don't want me to announce the winner. You're going to do that at the end, but you want me to critique.
That is correct.
All right. So we're all going to critique. And first of all, you both should be just so proud of your accomplishment. I remember when I was in moot court, it was a decision just to figure out whether I wanted to take the time to do it. Then there was the decision on whether the brief was good enough. Then there was each argument. And so, there's courage involved in 10 different steps along the way. And really, great job. I don't know how you feel about Zoom versus in person. There's good and there's bad with that. My guess is that as well as you both did, you would have done even better in person. And I look forward to having that interaction in the future. Before you came on, I had made a comment about, I'm pretty quiet, if there's any questions, go ahead, but really, let's see what they have to say. Well, 19 questions total in a 20-minute argument, which is really remarkable. And keep in mind, we didn't ask any questions in rebuttal. So really we can say 19 minutes, 19 questions. And no question is simple. It kind of leads to a follow-up and it takes you away from your argument. And really you both knew the points you had to make and you made them and you tried to incorporate the answers to our questions as best you could. And so I'm really very, very proud of you both. And then the last thing I would say is just individually, Gabriella, to me, you came out nervous, but you ended like you've been doing this your whole life. Your rebuttal was solid in terms of that. And Jessica, just throughout in general, it was almost like you got rid of your nerves during Gabriella's 9 minutes because you came out and really seemed quite confident. So very proud of you. And let me turn it over to how about Justice Stevens, if you want to go next.
Sure. I bear everything that Judge Singhal said. You both did fantastic. Your preparation was clear. I mentioned when we were just chatting, we've all been in your shoes and we know what it's like, and we know that those butterflies and what they kind of do to us. Before I give some feedback, just morbid curiosity, you all had tried to kind of set this up the way you wanted to before we started. Which sides were you going to argue before Lakshmi explained that was not going to be an option? Was it the ones that you eventually argued? It was. All right. So it ended up working out.
They outsmarted me.
Yes, I noticed that. No. All right. So, but yes, you both did fantastic. It's fun being on this side of it, kind of watching you guys, try and bob and weave through the questions. And you did have an active bench, which you'll have sometimes, and obviously other times you'll just be sitting there talking to blank faces. And so you might prefer one over the other, but you both did a great job handling, I think, all of us with us just lobbing stuff at you in a very short period of time. Gabriella, you did a very good job dealing with some tough questions. One of the things that I kind of like to see is that when there's an opportunity to kind of concede a point that doesn't necessarily hurt your argument, like it's always a good thing to do that, because I think that gives you additional credibility. And I look, as far as the law goes, I think you had the strength of the law on your side in the arguments that you were making. And so understanding that's why you probably didn't give up any position on that, but it's never a bad thing to consider that while you're doing it. But other than that, I thought you were phenomenal. Jessica, same to you. I think that, you did a very good job maneuvering through the questions and playing along to whatever, direction we wanted to take you on throughout this very short period of time that I'm sure felt like an eternity. And then, overall to you, I think that, you did a great job. So appreciate both of you and all the effort you put into what transpired today.
Justice Thomas, do you want to go next?
Sure. Let me start by saying, again, echoing what all the other justices said. Wow. 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 To be as sharp and ready and prepared as you guys were, and such a good grasp of the law as it relates to your argument, thoroughly impressed. I can't say that enough. I'm going to keep it as brief as possible. I'll start with Gabriella. Let me ask you: were you so confident that you're willing to argue either side? Just, hey, go at it. I'm ready to go. I know what I can do.
Yes.
That was immediately visible to me as you started. I mean, I know some people said that there were some nerves. I didn't really see it. And then when you ended with your rebuttal, wow. So I love the confidence. I love the fact that you stood your ground. There may be some discussions about concessions. Every once in a while, you may want to consider a concession if it's not going to hurt you. So that's going to require you to think either beforehand, okay, what are some of the questions that I may have to concede, or right there on the spot. So that would be my only, I guess, gripe, is taking concession when it's legit and you see it. Fighting it may hurt you in the long run. It may turn off the judge that's listening to you in the long run. Jessica, very agile on your feet. I mean, as Judge Singal said, we hit you guys with so many questions, and Jessica, you were just dancing. Not only were you able to answer the questions, you answered it the correct moot court way. Yes, Your Honor, and then give me the answer. Well, Your Honor, and then give me the answer. It would, and you, again, dancing, very agile. My only issue was the real world story you gave. I love the concept. I am one known to do that all the time. I just would have preferred that it really applied to this case. I'm a PI attorney. I kind of know what I need to bring in front of a judge like Judge Singal to keep my case in front of Judge Singal. And that example didn't touch home with me, at least. So that's the one thing I would say, that if you're going to use a real world example, make sure it is spot on. Make sure it's one of those where the judge's like, okay, and it moves on. Not one where you're going to invite a back and forth. But again, great job, both of you. I was honored to be able to listen and judge this. Thank you very much.
I'll briefly just add a few comments, echoing everything that the other justices have said. Congratulations to you both. It's a lot of preparation to get to this point today. And it was so evident in your arguments that you know the law, you were passionate about your sides, you did a great job advocating for your client. And that's really the end goal of this whole exercise. So congratulations. And I hope that you feel proud of all the work that you put in, because truly the deliberations in the breakout room were, we were conflicted because you both did such a great job. So Gabriella, you're so poised and confident, and it was very clear that you were ready to respond to our questions. You were willing to, really stick to your position. And so as you continue to grow as an attorney, learning to take those concessions is just something that will naturally come. So congratulations there. And Jessica, I love the confidence in your argument to incorporate a creative example. You'll continue to develop that skill and be able to, really tie it to your case. And as Judge Thompson said, I loved the way that you gave us that clear, answer right away and then explain, which I think is a really difficult skill, because we always want to, give the explanation first and say, well, this is why I'm going that way. So to have that confidence and come out right away and give us the clear answer, whether it was the one we wanted or not, I think was really great. So congratulations to you both. And again, thank you to the panel for allowing me to share in the experience with you.
All right, I won't take too long because I don't want to be the one standing in the way between now and you getting to know who the winner is. But congratulations to you both. I'll just say a quick couple comments stylistically. Gabriella, I love that you were like Ms. Pander said, that you're so poised. Each person has their own way of doing moot court arguments. Ms. Velarde, you used your hands a couple of times. I was noticing it, so that was a little bit distracting for me. But for you, you're very nimble, and that was a comment that was given to me when I was in my final round of the fine writer competition. And you have to be when you have judges asking you questions at the end of the day. As Professor Baxter always tells us, it's a conversation with the court, and that's exactly what you showed us today. Ms. Gabriella, you were a little bit more structured in your argument, and you kind of wanted to go where you wanted to go, and that gave us all your points. But at the same time, I didn't feel like you were as comfortable bouncing around, which is not a bad thing. If you get all your points out, that's fine, because you're just telling us your argument. But at the end of the day, you guys both have a great accomplishment under your belts, and I wish you luck in the future. And I'll pass it back to Kelly, I believe.
Thank you all so much for the feedback. I'm sure the competitors really appreciate it. I would like to take a moment and keep you in suspense just a little bit longer, because maybe there are some folks at home that don't realize a big part of this competition is also the written portion. So the competitors have worked so hard to get here today and demonstrate their oral advocacy skills to you, but they also worked super, super hard on writing briefs on this issue and submitting those briefs prior to their oral arguments. And with that, in the competition, we have a Best Brief Award that we would like to award and announce now. I'm going to turn it over to Lakshmi. Lakshmi, will you do us the great honor of announcing the winner of the 2021 Upperclassmen Competition Best Brief Award?
And the winner of the Best Brief Award is the person on the screen here, Jessica Velarde.
Thank you for that. I don't think my eardrums will ever recover. And finally, the moment that we have all been waiting for the past 2 months. Competitors, congratulations for making it to this point. But I would like to now announce the winner of the 2021 Upperclassmen Competition. It is my great, distinct honor to say that Jessica Velarde has won the 2021 Upperclassmen Competition. Congratulations, Jessica, and congratulations to you, Gabriella. You worked so hard. The arguments were incredible, and as Bethany mentioned, we really did have to come down to just little tiny nitpicking things here. So thank you both just so much for your time and for all your hard work. We're so proud to call both of you members of the Moot Court Honor Society, and we can't wait to see what you accomplish in the future. To our final panel, thank you so much for joining us. It's always an honor to host you all, and we really appreciate your time.
Can I say one thing before we all jump off?
Absolutely.
To Jessica and Gabriella, I really, from a former moot court competitor, I competed all over the country. Please hold it down for Nova when you get out there and start representing. Get out there, compete as much as you can,
Please.
And represent. Hold it down for NSU.
A round of applause. Thank you so much. And that is all for the 2021 Upperclassmen Competition. Thank you for all of the viewers for joining us, the people in the comments, our final panel, the competitors, the Moody's, the bailiffs, the competitors, the judges. And that is